Mr. Olgashin has submitted a motion to for return of personal property. Specifically, he has a Samsung cell phone identified by serial number in the motion, a blue X3 cell phone identified in the motion, and an atomic bear, which it is a tactical pin, according to the movement. Now, Mr. Oligashin, I'm sorry, I'm having to. It's your motion, sir. You have the floor. Amitabh, you may speak. It's your motion. Go ahead.
I have the motion filed. I just need the motion heard. It was an unlawful seizure of personal property. It is not against the law to record. Those phones were supposed to go into my truck, and I have it stated in the motion where the deputy, the same one that stole, keyword stole my tactical pen, he checked off the evidence box after I signed for my property. I asked him if he was going to put it in my property bag. He lied. Exact words stated in the motion. These are high value ticket items and need to be checked in across the street. I didn't realize he checked it into evidence until after I got out the next day on his unlawful charge. I had a medical emergency, which I was denied. And then I realized he had checked it into evidence and they refused to release it since. I don't even have those videos on my phone. They were virtual. And the other thing is this, he never put my tactical pen into my property bag. Right now, I'm filing a motion to release my property that was unlawfully and illegally seized. And Your Honor, I just want to get a hearing on the motion. Thanks.
Mr. Edelman.
By the way, one more thing for the record, please. I do have a video, which I don't know if I could get that in to the court. The deputy premeditatedly said on video, not only am I going to check your phone, I'm going to check it into evidence. I have a video recording of that. And like I said, the video is not even on my phone. It was recorded virtually. So like I said, I have filed a motion and I just need the motions heard for the release of my personal property. Thanks.
State, you've indicated you're not ready. Are you in a position to address Mr. Olagishan motion?
No, Your Honor, because the motion has not been properly filed with the court and served upon the opposing party, so we do not have access to its contents.
All right. Now, Mr. Olagashin, when you file a motion, regardless of what kind, the law requires you, it's called Rule 21A. The law requires you to file it not only with the court, but to give notice to the opposing party. In this case, it's the state of Texas.
Oh, yes, they do. It was e-file. I have the certificate of service on there.
I understand that, but e-filing is one step. Giving notice or making sure that the state gets a copy of it is the second step that's required.
Who is assigned to this case?
Sir?
Elder Man Adder, I'm guessing that's who's assigned to the case?
Yes, sir. But you're not listening to me. You're required to make sure filing it with a clerk is one step. You have a second step. You have the obligation, and in fact, it's supposed to be recited in the motion, that you certify that you have given notice, in other words, delivered to the state a copy of that motion.
That is what the state of Texas and Bay County participates in e-file. So yes, the state should have inserted the copy. That's where the comes in.
To me. You're not listening to me, Mr. Olagashin. Take the second step. That is where you personally certify that you have given notice to the state of that motion. And we're talking about the prosecution. Take that step we'll finish the motion, all right? It's a requirement of law. That's what I told you last time, that we should
Your
have.
Honor, Your Honor, I have filed motions in the past. This was electronically served to Bay County attorney. It was served through the e-file process. There's a reason he knows there is a hearing today. Otherwise, he wouldn't be here representing the state. Your Honor, I filed a motion for the return of my unlawful seizure of my personal property. I just need the motion heard.
Well, we can't hear the motion until both sides are ready. And this matter, as I said a while ago, you took the
So
first
is the
step.
motion granted or denied?
It is not heard because I cannot grant it nor deny it, since the state is not ready, because you have not properly given the state notice under law.
Oh, Your Honor, for the record, I gave the state notice. That is why there's a representative from the state, Elderman Ader, I don't know how he says his name.
Edelman,
There's a reason he's representing the state right now. So they got due notice of the hearing, Your Honor.
again, due notice of the hearing was given by the court coordinator. The
Which
actual
includes
motion
my
itself,
motion.
hello, the motion itself was required to be delivered to the state. You have not done that. Find out, if you need to, find out what step you have to take. It's the second step. We'll reset it. How many days would you need, Mr. Edelman, if you get notice?
Delivered electronically.
Your Honor,
Okay.
I
I'll
only
coordinate
need
with the
3
court
days.
coordinator.
Mr. Edelman,
I only need 3 days, Your Honor.
all right. Today's Wednesday. All right, we'll do it by Monday. We'll recall this Monday, Mr. Olagas.
Okay.
Please,
So we're
please.
recalling this on the grounds of the state not being ready. Yeah.
No, sir. Well, in a very technical sense, yes. But the problem is that the state's not ready because the movement, Temitop Olagashan, has not given proper notice. Do
No,
that.
that's not true, Your Honor. I gave proper notice. I filed this on the 19th of December, and there is a reason the DA's office representative, who is Elderman, is here today, because he got ample notification that there is a hearing set for today. So he did not do his due diligence, hence us having to do reset. So had he researched the
Mr.
case, he
Olagashan.
got ample notice of the motion.
Mr.
If I may,
Olagashan,
please. It was not e-filed, sir. You sent it to County Court 5 email. You did not e-file it.
Actually, that's incorrect. It was e-filed, and I
No, sir,
sent you
because
the
if it was
updated.
e-filed,
Wait,
it would have been
listen.
stamped,
hold on,
and it is not
It-
hold
stamped.
on. I will repeat.
It
one
was
last time.
e-filed. I
Hello,
updated it, is
Mr.
what I sent in
Olagashan,
the
are you
email.
gonna listen to me or are you gonna keep talking?
Oh, I can hear you. I was just correcting her error.
Well, the
I am not
problem
in
is
error,
that
sir.
I'm not, the next time any one of you speaks out of turn, I'm gonna find you in contempt. How's that? Both of you. Now, I have said it at least 3 times. Rule 21A says that you are required to give notice to opposing counsel or opposing parties. If you don't know what that means, find out, because you have not complied.
I know what that means.
Hello? Comply with that part of the law. We will have the hearing Monday. If you don't, we're not going to have a hearing Monday until you comply with the law. Now, the reason that the district attorney is present, because he was given notice that there was a hearing. He was not given notice of the motion itself. That's what's required. Do that. We'll have a hearing Monday and we'll get this matter finished.
All right,
All
Judge.
right. All righty. We'll see you Monday, God willing.
All right, Judge.